Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our lecture number 33. The topic is very, very important. The topic is Explain Order 21 of Supreme Court Rules governing SLP in civil matters. So, before going to the topic, it is our regular practice that we recite the preamble of the Constitution of India to praise our founding fathers, their aim and goal, what they had towards our nation. So their vision is our mission. So therefore, let us recite preamble with a sense of sentiment and commitment, with a feeling that it is our goal and preamble our soul. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Let it be our everyday prayer. Now, so far we have delivered many lectures even on the particular topic, that is special leave petition. But it is always important, before approaching the topic, Order 21 of Supreme Court Rules 2013, before approaching the topic, let us ask ourselves this question: where in the Constitution of India that they have prescribed about special leave petition? We need to find out the roots of what we are going to study. That is how we have to approach. Article 136 of the Constitution of India has two clauses, and it is extraordinary appellate jurisdiction of the Supreme Court. It is also a plenary jurisdiction vested with the Supreme Court. It is a discretionary power, not as a matter of right that we can claim. So therefore, the Honorable Supreme Court, only when they satisfy their conscience, only when they are satisfied that there is a merit in the case, they will interfere, otherwise they will not interfere. So now let us understand what is Article 136. How does it start with? Notwithstanding anything contained in this part, that is part 4 of the Constitution, the Supreme Court may, in its discretion, grant leave to appeal against any judgment, degree, determination, sentence, or order passed in any matter by any court or tribunal in the territory of India. If you look at the plain meaning of these provisions, the Supreme Court may, in its discretion. So it is not obligation on the part of the Supreme Court to interfere. It is a discretion for them to interfere or not to interfere. Against what? Against any judgment, any order, be it interim order or be it final order, passed by any court. If you look at civil appeal or a criminal appeal, there they have specifically said that you have to approach the Honorable Supreme Court against the High Court order. But you will not find such a provision in Article 136. Nowhere they have stated it is an appeal only against the High Court order. So therefore, it is not a mere appellate jurisdiction. It is extraordinary appellate jurisdiction. Now coming to clause 2. of Article 136. We can divide these two clauses under two divisions. Article 136 clause 1 says when a Supreme Court can interfere or when you can file, what are the circumstances under which you can file special leave petition. Number 2, clause 2 is under what circumstances the SLP will not lie. So therefore clause 2 is an exception to clause 1 of Article 136. So what is Article 136 clause 2 says? There cannot be any special leave petition against any judgment, determination, sentence or order passed by any court or tribunal related to, made by or connected with armed forces. So therefore any tribunal established under the armed forces, you cannot bring within the meaning of order or within the meaning of judgment which falls under Article 136 clause 1. So these are the two important aspects that you must understand. Having understood Article 136 clause 1 and Article 136 clause 2, on previous occasions we have dealt. Sir, you say it is only a discretionary power, but the provision says may grant leave against any judgment, any order, such a wide power vested under Article 136. So where do you find the restrictions? The restrictions imposed by whom? The restrictions imposed by the Honorable Supreme Court itself. Being a discretionary power, it cannot exercise in every cases. Therefore, the Honorable Supreme Court has regulated itself under what circumstances the SLP can be interfered. There are certain instances when there is an order passed by the courts below, when it is not a speaking order. When it is not a speaking order, that means its conclusion is not based on any reasons, any materials. It is perversity, improper rejection or reception of vital evidence. So therefore in such circumstances the Honorable Supreme Court will interfere. When there is a miscarriage of justice by not complying with the principles of natural justice, it is basic fundamental principle of law that other side should be heard, right? So therefore when there is a gross violation of principles of natural justice leading to miscarriage of justice, then Supreme Court will interfere. Supreme Court will interfere when there is a substantial question of law. What is substantial question of law? Those questions of law arises in many cases. When it is such cases pending before various high courts, there may be a conflicting decisions. So therefore law is to be settled by the Honorable Supreme Court to guide all the high courts and the trial courts to follow the basic principle, the settled principle of law. Therefore, in order to avoid any confusion, any contradictory judgments, therefore the Honorable High Courts and the trial courts under Article 141 of the Constitution of India, it has a binding nature. So the Honorable Supreme Court's bounden duty, I call it as a constitutional duty, is to settle the principle of law, to show the light for the remaining courts to follow. It is the leader which leads the entire nation. The constitution may be there, provisions are there, but who is the final interpreter of those provisions? It is the Supreme Court of India. The Honorable Supreme Court judges, when they say this is what it is, that is the constitutional law. So therefore, we as an advocate on record, we are in a position to assist the Honorable Supreme Court to be the final interpreter. So we are assisting, this is what the right interpretation. When you are in a position to convince the Honorable Supreme Court, then you have helped so much immensely to render justice. So the advocate's duty is very, very vital with respect to advocates and advocate on records in the Honorable Supreme Court of India is concerned. So, having understood under what circumstances the Supreme Court will interfere, now we need to move on to Supreme Court rules. As we earlier we have seen Article 145 Clause 1 of the Constitution of India empowers the Supreme Court of India to frame rules with respect to the practice, with respect to how the writ jurisdiction has to be exercised, and what is the format of writ petition, how civil appellate jurisdictions, criminal appellate jurisdictions, statutory jurisdictions, review jurisdictions, advisory jurisdictions are dealt in detail. It is the procedure which prescribes. That is what the Supreme Court rules 2013, dear friends. This is very, very important. So, Constitution of India 136 read with Article 145 Clause 1, and then we are moving on to the Supreme Court rules Order 21. Order 21 of the Supreme Court rules, which specifically deals with special leave petitions in civil matters. When it is specifically says it is a civil matter, therefore we have a criminal matters also. So now we will be dealing only with civil matters. On last two occasions, we have seen under what circumstances the SLP can be filed. One, you can seek a certificate from the High Court with a prayer that our case is a fit case to be decided. That means once a certificate is issued, it becomes a civil appeal. When Honorable Supreme High Court refuses to grant a certificate, then against the refusal of the certificate, you have no other remedy except approaching the Honorable Supreme Court by way of special leave petition. The limitation is 60 days. But when you do not approach the High Court for the certificate, once you have seen, you have perused the High Court order and your client is aggrieved, you directly approach the Supreme Court under Article 136 special leave petition without a certificate, without seeking for a certificate from the High Court. Then what happens is, the limitation is 90 days. 60 days and 90 days. These are the two ways to invoke Article 136. Now, what is the format of SLP? Where do we get it? This is very, very important question, dear friends. Form number 28 of the Supreme Court rules deals with the format of special leave petition. It has got 8 vital organs of SLP. Like you introduce against first paragraph which says that against which order you have preferred a special leave petition. Number 2, questions of law. 3 and 4 deals with declaration. 5 is grounds. Then interim prayer, grounds for interim relief, then main prayer, thereafter interim relief or interim prayer. We have seen that in the special leave petition, unlike other applications or other petitions, there is no need for filing separate application seeking interim relief. As a part of the SLP itself, you will seek interim relief. Therefore, there is no separate application for interim relief. Now, how do you prepare the list of dates and events? Based on the chronological order, you will prescribe the list of dates corresponding to that events in chronological order. Thereafter, appendices. When you are correlating or when you are relying upon certain statutory provisions or constitutional provisions, you will extract those relevant provisions and you will put it as appendices. Thereafter, annexures. Annexures should be numbered and should be given like annexure 1, annexure 2, annexure 3. Thereafter, those annexures has to be filed not collectively, individually it has to be filed. For example, copy of plaint means it should be copy of plaint, copy of the written statement, copy of deposition of PW1 or TW1, It cannot be made collectively, right? For the convenience of the court. So we have seen all these provisions, dear friends. Now we are moving on to the provisions where we have left earlier. And how is our approach is, we ask a question to ourselves and let us try to find answers for ourselves. That is the right, in my humble opinion, that is the right way of approaching any constitutional provisions or any matter. For example, if you are filing special leave petition, what is the purpose of filing special leave petition? You try to answer yourself. If you are coming to the Honorable Supreme Court, practicing in the Honorable Supreme Court, why should you practice in the Honorable Supreme Court? Why? And why do you want to become an advocate on record? There are many advocate on records practicing here. Why do you want to become an advocate on record? Ask yourself and don't try to find answers outside. If you want to find answers, you have to find within yourself. That is important. Now the question, dear friends, special leave petition order 21. I would like to draw your attention to rule number 31F, because on the last date we have left up to E. 31E we have dealt already. We have spoken about what is the sanctity of the affidavit. Now let us move directly to F. Hope you are with me, dear friends. 31F. Now the question what I am going to ask is, how SLP shall be arranged in what order? How the SLP shall be arranged and in what order it has to be arranged. Now let us find the answer. First, 31F, within that, 1. List of dates in terms of clause B of subrule 1. What does it say, subrule 1? It has to be based on a chronological order. So list of dates, we have to mention it in a chronological order. So that is over. Now see, dear friends, while you are reading, you should imagine that SLP paper book is in front of you. Image should be there, then only you can easily correlate. If you say list of dates means that B, from B till C, whatever E, it should be there in front of you. Thereafter you are turning the page. What is the next page? Certified copies of the judgment and order against which the leave to appeal is sought for. So always page number 1 is the impugned judgment, begins with impugned judgment. So after list of dates, you will file the judgment, certified copies of the judgment and order against which the leave to appeal is sought for. Number 3, now judgment is over. Now what is there next? Number 3 is the special leave petition in the prescribed form number 28. So we have already seen form number 28 is appended to these rules only. So special leave petition in the prescribed form number 28. Number 4. So after SLP is over, affidavit is filed. What next? Appendix. What is there in appendix? The relevant provisions which we are going to rely upon will be cited there. For example, you want to refer to section 35 of the Advocates Act, professional misconduct. I am giving you an example. So a matter revolving, you are going to file a special leave petition revolving around professional misconduct, and we are going to rely upon section 35 of the Advocates Act. In the appendix, you will extract section 35 of the Advocates Act, because to be more convenient to the honorable judges, you reproduce there. Appendix containing relevant provisions of the Constitution or statutes, ordinances, rules, regulations, bylaws, orders. Dear friends, when you read this, they have given it in a certain order. Constitution is the source of all powers. Therefore, they have given the Constitution. Statutes, how Who makes the statutes? Either parliamentarians or the state legislative assembly. They derive their power from union list, state list, or concurrent list. Where does it come from? From the Constitution of India. So, therefore, statutes, ordinances, it is equivalent to the statutes, rules, thereafter rules, then regulations. This is the law which says, dear friends, regulations cannot violate the rules. Rules cannot violate the statutes. And statutes cannot violate the constitutional provisions. That is the law. So rules must be obedient to the statutes. Statutes must be obedient in consonance with the constitution. So who is the legendary? We cannot say it is a statute. Legendary law is constitutional law, dynamic law. So this is how you have to ask why they have given this in this order. Then you will understand. Annexures, if any, it is not something. See, annexures, if any, filed along with the specially petition, giving the page numbers. Now, the question is how it has been arranged. We have given. G. If notice is ordered on the specially petition, the petitioner should take what is the steps? Now we have filed it. Matter is coming up for admission before the honorable court. Now you have appeared. There are two possibilities. One is dismissed. That is one possibility. Another one is issued notice. When notice is issued, this is frequently asked question, dear friends. Any questions can be asked either in 2 marks, 5 marks or 10 marks from this order 21. So if notice is issued, it is whose duty is to take steps to serve notice on the other side? It is the petitioner's duty to serve the notice on the other side. That is why sometimes when there is urgency, we say, Dasti, by hand we will deliver it. For example, an interim order is challenged. Main suit is pending before the High Court. In the High Court, there is maybe a suit for declaration or suit for permanent injunction, in which the plaintiff prefers Order 39, Rule 1 and 2 for injunction. That was rejected, that was dismissed. Now plaintiff is aggrieved out of the interim order which declined to grant him injunction. He prefers an specially petition before the Supreme Court. In such a scenario, the petitioner, once notice is issued against the interim order, then he can serve on an advocate who is contesting in the High Court on behalf of the defendant. You can serve on the other side counsel also when main suit is pending before the High Court. That is what they say. I read, dear friends, if notice is ordered on the specially petition, the petitioner should take steps to serve the notice on the respondent, provided that in the case of a specially petition against an interlocutory order or in any proceeding pending in the court below, the notice may be served on the advocate appearing for the party in the court or tribunal before whom the matter is pending. Now this is clear. Now moving on to sub-rule 2, 3.2. No petition. Now the question is, what is the clarification with respect to the earlier specially petition? For example, when you are filing a specially petition, you have to particularly state whether have you preferred any specially petition earlier against the impugned judgment. If you have filed it, then what is the outcome? You have to state before the Honorable Supreme Court. That is very important. Otherwise, it will amount to suppression of the material facts. First and foremost, we cannot files second special leave petition. If somebody wants to suppress the first SLP and then prefers the second SLP, it is always a statement that we need to make that we have preferred SLP, but due to change in circumstances, we are preferring the present SLP. So the rule says, dear friends, no petition shall be entertained by the registry. They are talking about Supreme Court registry, unless it contains a statement as to whether the petitioner had filed any petition for special leave to appeal against the impugned judgment or order earlier, and if so, with what result, duly supported by an affidavit. Here, why affidavit? A person should be made accountable, therefore an affidavit of the petitioner or his parocor only. Who is parocor? For example, dear friends, the representative, the dependents, one who is contesting on his behalf. For example, an accused is in jail and he wants to prefer a special leave petition for bail. Wakalat can be executed, even affidavit can be executed by him. But in order to avoid inconvenience to the party, a wife or a son or even a friend can file an affidavit on his behalf stating that I am a parocor. So on his behalf, we have seen so many affidavits being executed by the son or the wife of the accused. Number 3, the court shall, if it finds that the petitioner has not disclosed the fact of filing a similar earlier petition. Just now we have seen that we need to make a statement about the earlier filing SLP. Then if you are not stating about the earlier filing of SLP and we have suppressed what was the outcome of the earlier SLP, then what is the effect? What is the consequence of that? That is what 3 says. The court shall, if it finds that the petitioner has not disclosed the fact of filing a similar petition earlier and its dismissal by this court, dismiss the second petition if it is pending. So if you are suppressing the earlier SLP, you are not stating anything. If it comes to the knowledge, because your opponent is always there, even the Supreme Court registry now e-courts, digital courts. Once we put the petitioner name, order name, everything will come. So digital world has prevented the falsehood, dear friends, to a certain extent. The court shall find that the petitioner has not disclosed the fact of filing a similar petition earlier and its dismissal by this court, dismiss the second petition if it is pending, or if special leave has already been granted therein, revoke the same. If second special leave petition is filed, by suppressing the earlier special leave petition, then second special leave petition can be dismissed. For example, the second SLP where leave is granted, then leave can be revoked, can be cancelled, and it can also get dismissed. What is the principle involved? A person who approaches the court must approach with clean hands, must come out with true disclosure of facts, material facts. One who wants to seek relief must do with clean hands. So that is very important, dear friends. Number 4 now. The petition. Now how about the memo of parties? The petition shall also contain a statement as to whether the matter was contested in the court appealed from, and if so, the full name and address of all the contesting parties shall be given in the statement of facts in the petition. So generally we don't give it in the facts, dear friends, though the rule says we generally give it in the memo of parties. Who are all the parties? What is their address? Whether are they contesting parties or the pro forma party? Contesting respondents or pro forma respondents? What is the difference between contesting respondents and pro forma? We file a petition to seek some relief against our opponents. We want the court to interfere, therefore they can direct the respondent. So a petitioner who seeks a relief against the specific respondent, then he becomes a contesting respondent. But who is not a petitioner who does not seek any relief from particular party, but still they make it as a party in order to complete, then they become a pro forma party against whom the relief is not sought. So that is why the registry always mandates the AOR to mention whether are they pro forma respondent or they are contesting respondents. Now 5, the special leave petition. What is the question is alternative remedy, whether have you exhausted your alternative remedy. The special leave petition shall also contain a statement as to whether a latest patent appeal or writ appeal lies against the impugned judgment or order and whether the said remedy has been availed. For example, we come directly against the single judge order passed by the Honorable High Court. So you need to inform in the SLP whether is there any latest patent appeal is available to you or writ appeal is available to you. If so, have you approached and what is the outcome? So therefore, they are looking for alternative remedy. Now, dear friends, the fourth one is the petition shall be accompanied. The petition means special leave petition shall be accompanied by a certified copy of the judgment or appeal from. So what is the judgment we are impugning or we are challenging? That certified copy is to be there. An affidavit in support of the statement of facts contained in the petition. But generally in practice, in the special leave petition, we don't state that whether the earlier SLPs has been filed or whether is there any latest patent appeal or appeal is exhausted or remedy is available or not. Generally we state all those facts in the writ petitions, but not in the special leave petitions, but the rule prescribes all these to be mentioned in the SLP. Now, when annexures are accepted, now fifth point, dear friends, when annexures are accepted, what sort of annexures are accepted by the registry? Because you prepare SLP, SLP has to be accompanied with annexures for two purposes. Either your annexures must support your question of law, which you have urged in the special leave petition, or your annexures must support your grounds, what you have urged. Therefore, you can easily get the relief what you have claimed in the prayer. So how the annexures to be annexed, filed? So annexures, generally the general rule is you have to file the certified copy of the annexures. So where do you get those certified copies? You have to apply, a party has to apply for a certified copy. If it is a trial court proceedings, from the trial court. If it is annexures which you want to file it with respect to the high court proceedings, you have to apply for a certified copy of the appeal and the high court judgment. So certified copy is required, that is the rule. So when there is a rule, there is an exception. What is the exception here? When you are unable to get the certified copy because there may be imminent danger to your property or to your life, certified copy may take maybe 1 month or 2 months, maybe 3 months, we do not know. But till then, our client cannot wait. So therefore, in the interest of justice, he might have the same copies, but he must assure the Honorable Supreme Court that these are the true copies of the original. So he has to sign it, true copies. That means you need not apply for the certified copy. Preference is certified copy. If not, your annexures has to be stated as a true copies. That is what they have said. No annexures to the petition shall be accepted unless such annexures or certified copies of documents which have formed part of the records of the case in the court sought to be appealed from, provided that uncertified copies of documents must be accepted as annexures. Uncertified copies accepted as annexures if such copies are affirmed to be true copies upon affidavit. Therefore, when we prepare specially petition affidavit, we say the annexures filed herewith are true copies of the originals. So we make the petitioner or the respondent accountable to the court. Now, how many spare copies to be filed? That is the sixth one. The petitioner shall initially file only one spare set of the petition and the accompanying papers, and when the matter is refiled, after removing the defects, the advocates on record or parties appearing in person shall submit at least 3 sets of paper books along with set of original paper with the declaration that the paper books are complete in all respects. So this is about spare copies. First we will file the original and then 3 copies along with that original after removing the defects with a declaration. Now coming to the 7th point, this is very important, dear friends. What is the circumstance here? Let me read this and then explain you. Where any person is sought to be impleaded in the petition as the legal representative of any party to the proceedings in the court below, the petition shall contain a prayer for bringing on record such person as the legal representative and shall be supported by an affidavit setting out the facts showing him to be the proper person to be entered on the record as such legal representative. So when you want to move an impleadment petition or when you want to bring LRs, legal representatives, in the place of a deceased person, so what you need to say? See, for example, a case cannot be filed by a dead person. In one of the cases, I have filed on behalf of, say, A person. A is my client. And I have filed the SLP. Notice is also issued to the other side. After issuance of notice, my client A died. Thereafter, his son had called me and he has told, "Sir, this is what happened with my father and case is pending. You have to bring it to the notice of the court that so and so has died, and you must bring all our legal representatives, legal heirs of the deceased must be brought on record as the petitioners." Then immediately I asked, "Please send me the death certificate of your father. Secondly, legal heir certificate." So based on that, we can prepare an application. So this is what they are saying, dear friends. When you are making an application to bring on records the legal representatives, what you have to state? You have to state that you are the legal heir or legal representatives and must be supported by an affidavit and setting out the facts showing him to be the proper person to be entered on the record such as legal representatives. Now the 8th point, where at any time between the filing of the petition for special leave to appeal and the hearing, you file a petition but the matter has not ripened for the admission. So in between, your client has died. Where at any time between the filing of the special leave petition and the hearing thereof, the record becomes defective by reason of the death or change of status of a party to the appeal or for any other reason, an application shall be made to the court stating who is the proper person to be substituted or entered on the record in place of or in addition to the party on record. Provisions contained in Rule 30 of Order 19 shall apply to the hearing of such applications. So, what they are saying, dear friends, when you are filing a special leave petition and before the matter is ripened for hearing, party dies, or there is a change in the position, or for any other reason it has become defective, you have to bring on record that so and so has died, therefore legal representative should be done. So what sort of procedure that has to be followed? It generally comes up before the registrar court. If there is a question with respect to, if the respondent claims or there is a question that they are not the legal heirs, the matter can be placed before the chamber judge, and chamber judge can go into the question who is the proper legal heir of the deceased. If the chamber judge doesn't find time to do that, they can even refer the matter to the high court or the courts below, even the trial court, to ascertain who are the legal heirs and then submit their report within the stipulated time. This is what Order 19 says. Order 19 of Rule 30 says. Sorry, Rule 30 of Order 19. Please look at page 48. Let me read that, dear friends. Upon the filing of such an application for impleadment, application to bring on record the legal representatives, when such an application is filed, upon the filing of such an application, the registrar of the court shall, after notice to the parties concerned, determine who in his opinion is the proper person to be substituted or entered on the record in place of or in addition to the party on record, and the name of such person shall thereupon be substituted or entered on the record. So when there is no dispute, after issuance of the notice, they can do that, provided that no such order of substitution or revival shall be made by the registrar where a question arises as to whether any person is or is not the legal representative of the deceased party, or where a question of setting aside the abatement of the cause is involved, and in such a case he shall place the matter before the court for orders. Provided further, where during the course of the proceedings it appears to the registrar that it would be convenient for the enquiry that investigation in regard to the person who is substituted on record be made by the court appeal from or a court subordinate thereto, the registrar may place the matter before a judge in chambers, and the judge in chambers may thereupon make an order directing the court appeal from to investigate into the matter either itself, chamber judge can investigate itself, or cause an inquiry to be made by a court subordinate to it after notice to the parties, and submit its report thereon to this court within such time as may be fixed by the order. On receipt of the report from the court below, the matter shall be posted before the judge in chambers again for appropriate orders. So far what we have seen, dear friends, how SLP has to be arranged. I am summing up, dear friends. So it shall be arranged in a proper order as mentioned in the Supreme Court rules, and then appendices has to be annexed, annexures to be properly arranged in a chronological order. When you are adding the memo of parties, whether are they contesting parties or pro forma respondents, that you need to state. When you are seeking for an impleadment, what you need to state is are you the legal representatives of the deceased. That has to be accompanied by an affidavit. So everything we have seen, dear friends. So further we will be seeing in detail about the other subsequent rules also in the upcoming session. Thank you so much for your patience hearing. Thank you so much.